Protecting Refugees, Non-refoulement Principle and the Scalabrini Center of Cape Town Case de Rebus November 23, 2024 Section 22, and of the Refugees Act 130 of 1998, were presented by the Refugees Amendment Act 11 of 2017, which came into force on January 1, 2020. Section 22 and Regulation 9 and Form 3 of the Refugees Regulations provide that asylum seekers who fail to renew their asylum visa within the period of 30 days on expiry of their asylum are considered to have abandoned their asylum application. This creates a presumption of automatic abandonment of the application, in an instance where an asylum seeker has failed to renew their asylum within 30 days. Moreover, the provisions place asylum seekers who hold genuine claims at a disadvantage because their genuine claims may lead to further persecution as a result of being deported to where they are from. This perception gives rise to an analysis of the principle of non-refoulement, which provides against one being returned to a place where there is a possibility of facing persecution. In Scalabrini Center of Cape Town and another v. Minister of Home Affairs and others 2024 BCLR 592, the Western Cape High Court found that the relevant provisions of the Act are inconsistent with the Constitution and further sought the Constitutional Court to confirm the order of invalidity. In the judgment, the CC noted that, when read, the concerned sections of the Act mean that asylum seekers who fail to apply for the renewal of their asylum seeker visas are considered illegal foreigners for purposes of S32 of the Immigration Act 13 of 2002 and they may not reapply for asylum. In the light of the submissions made above, this research piece seeks to assess the principle of non-refoulement in terms of S22 and 22 of the Refugees Act as read with Scalabrini Center of Cape Town. An analysis of the principle of non-refoulement Section 2 of the Act gives birth to the principle of non-refoulement by asserting that no person may be refused entry into the South African Republic, extradited, expelled, or returned to another country if such return or refusal will subject such person to persecution or threaten his or her safety and security. This section basically affords non-South Africans a claim against the state. The Convention relating to the status of refugees defines a refugee as any person who, as a result of a well-founded fear of persecution, is outside his or her country of origin and fears the return to such country because of issues of race, religion, political opinion, etc. CCR 107. In this instance, refugee means protection, so a refugee is a person who desperately seeks protection from another state against his or her country of origin. Kapindu submits that the idea of refugeehood is premised on the principle of surrogate protection. In instances where a country fails to promote and protect human rights and its citizens, the author adds that the four major challenges that refugees encounter include gaining access into a state, safeguarding the right not to be returned to the harmful jurisdiction, arguing the entitlement to the refugee status in terms of the laws of the host state, and the challenge of enjoying the basic human rights of such host state at 108. Ultimately, it can be noted that refugees are vulnerable people. The United Nations High Commissioner for Refugees went as far as submitting that the risk of non-refoulement can be curbed by efforts aimed at ensuring that the host country understands the fact that it has a legal obligation to protect refugees at 109. The fact that refugees are people who flee dangers to seek protection from other countries creates an ethical obligation for the receiving countries to protect such refugee seekers. Kapindu concedes that the non-refoulement principle applies erga omnes, hence the need to ensure that it is duly protected and enhanced by the international community at 113. Additionally, the author submits that the principle is not only limited to refugees but every person who is likely to be exposed to danger when returned to his or her country of origin at 113. In Mohammed and another v. President of the Republic of South Africa and others 2001 SA 893, it was submitted that the non-refoulement principle makes no distinction between expulsion, return or extradition of a person to another state to face an unacceptable form of punishment. All are prohibited, and the right of a state to deport an illegal alien is subject to that prohibition at 115. In Abdi and another v. Minister of Home Affairs and others 2011 SA 37, it was held inter alia that deporting a person to another country would amount to the subjection of such person to degrading and cruel punishment, which goes against the precepts of the Constitution. Jurisprudence teaches us that a person who flees their country of origin because of fear of being persecuted, killed, or placed in inhumane situations may raise the principle of non-refoulement as a defense against being returned to where they are from. A legal analysis of Scalabrini Center of Cape Town during March 2020. The Scalabrini Center of Cape Town and the trustees of the Scalabrini Center of Cape Town launched a two-part application at the Western Cape High Court. In Part B, the applicants sought a declaratory order that the relevant provisions of the Act are inconsistent with the Constitution and, therefore, invalid. In arguing for the order sought, the applicants submitted that the respondents had created a system wherein asylum seekers who have failed to renew their visas are deemed to have abandoned their asylum applications. Additionally, the applicants contended that the sections violate the principle of non-refoulement in that they allow the returning of asylum seekers to places that are considered to pose threat to their lives, physical safety, freedom, and places that are likely to subject the asylum seekers to persecution. In the court quo, the respondents opposed the relief sought by arguing that the relevant sections did not violate the non-refoulement principle, because they were justifiable under S36 of the Constitution. The respondents argued that the limitation relates to the backlog that is created by the large number of inactive applications